experts in the room. Yes, Mr. Hoffman, do you have a comment?
We're monitoring the YouTube feed, and we don't see it yet, so Kevin just went to see.
Okay,
if
so I
that's-
should repeat everything once we get YouTube spinning, probably?
I think so.
All right, so that was good. I hate to ruin the surprise for you all, but I'll say something substantially similar in a few minutes.
Were you able to catch that?
I've been informed that YouTube is broadcasting, and it's clear that the microphones are working at least inside the room. So being 2:12, I will bring us out of recess on HB 1677. The way we're going to conduct this is that 2 days ago, we walked through a version of 1677, an Umberger amendment, and we found a number of places where we thought alternative language ought to be considered. We convened a work group. The work group consisted of Mr. Hoffman and Mr. Ripple of the LBA. The Attorney General, I believe, was directly involved, General Formella, and I believe Representative Bob Lynn also participated in the work group. Were there any other members of the work group?
No.
Okay. So the process I think we can follow today is to take the highlighted version of the changes in the Umberger Amendment, which is 0936, and Mr. Hoffman will walk us through it. He'll set the stage for the change that was made and his interpretation of the rationale behind it. And if there anybody on the committee that has questions, we'll dive into it at that point and bring subject matter experts up. And I would like to encourage the plaintiff's counsel to be assertive. If you want to say something, I want you to make sure you know you have my permission to please wave at me, and I want to have you heard. Okay? All right. So with the stage set, Mr. Hoffman, would you please lead us off?
Yes, thank you. As you recall, in the last meeting, the committee took several straw poll votes on certain parts of the amendment, and then agreed that things would be on hold for the work group to consider. So as Kevin put this document together, he's noted that in the margin. So where you see work group removed, that was based on work of the work group. Further down, you'll see language revised by committee. Just to distinguish between...
So Mr. Hoffman, I should have given you one more guideline. There are people that need to know this material because they'll be voting on it, and this, for some of them, is the first time they've seen these changes. So, so I think we can take our time and be expansive in the description of each item, if please.
Sure. I just wanted to note the difference between the two types of remarks in the margin.
Oh, okay. I thought you'd already started rolling and just
No.
knocked out two of them already.
No, not quite that quick.
Okay.
So if we look on page 1 on line 13, in the earlier versions, a retired judge was listed there as a possible candidate for administrator. The work group met, and based on the likelihood of a judge electing to do this and other complications with the judicial retirement system, the retired judge was removed from this section. And if to the members of the work group, if I'm not describing this the way you'd like to, or reflecting accurately, please chime in.
And I'll be prone on some of these to use my judgment of whether or not it's controversial. If I don't think it is, I won't stop Mr. Hoffman from going to the next one. But if anyone does have an issue with any of these things, again, just get my attention and we'll make sure your curiosity is satisfied.
At the bottom of the page, which is the next change, the committee had made this change to the definitions of physical abuse and sexual abuse, which I believe were adopting the common law reference and just cleaning up some differences in the RSA references.
2 days ago, we did not really explore the meaning of single incident and what that could mean to how the guidelines get developed. And we've otherwise have accepted the plaintiff's language on this, but I have concerns that the single incident may cause, in this definition, I think a single incident is sufficient to initiate a claim, but what I'm curious about is if the impact of each incident being a claim, if somebody is abused in the same way 10 times, is that 10 individual claims, or would the guidelines incorporate as a contributing factor the fact that there were multiple incidences and that would presumably change the interpretation of what part of the range to be on? And we did not have that conversation, but I'd like to just make sure we all are in an agreement and that statute would support what we're thinking. So, Representative Lynn, do you have something to add here?
Yeah, I do, and in two regards. One, as you point out, we didn't discuss that, but yesterday in the work group, we did sort of focus on this, and I think our thinking at the time yesterday was that for definitional purposes, it was okay to say a single incident, because as you point out, a single incident should be enough to trigger invoking the process. We thought that the way to make it, the concern we had yesterday was to make it clear that whether there was a single incident or multiple incidents, the cap applied as a cumulative matter. In other words, somebody couldn't come in and say, well, I was sexually assaulted 10 times, so therefore I'm entitled to, receive the cap for each one of those. So 10 times 1.5 million. So we put some language in Roman numeral 5 to cover that. But as you pointed out,
Could
Mr.
you
Chair,
do page and line?
Sure. On page 4, lines 9 through 12, we added some language, indicating that the cap for both sexual abuse and the lower cap for physical abuse only applies in the aggregate to all claims. So we thought we had covered it, but as you pointed out to me earlier before we actually started our meeting, arguably it has not completely covered, because we did not focus on the situation of suppose the guidelines were to say, some form of physical abuse, let's say, would be worth, I'm just making this number up, but let's say they said some form of physical abuse would be worth $10,000. And then suppose that, so it's well under the cap, but suppose there were 10 incidents of physical abuse of that kind, would that mean that automatically the number was $10,000 times 10? I think while the guidelines may factor in the number of time, the amount of the abuse or the number of times it occurs, I think there was some concern that it shouldn't just be automatic. So you had suggested, I think, some language that I don't remember the exact language that you suggested, but I think it was a good way to handle it.
So my thought on tweaking the definition was so that we don't violate the idea that a single incident in its own is sufficient to say physical abuse means a single incident and then add or multiple incidents with an S. And so my thought there is that if a person is victimized effectively the same way with a beating multiple times, it seems to me that we would want to have one claim filed and not 8X claims or whatever the number is. So Attorney General Formella, we've not talked about this at all, and so what are your thoughts on how this term single incident, does that really invite the plaintiffs to file one claim per separate incident?
Thank you, Mr. Chair, for the question. I don't have a concern about that, reason being that the term claim is defined as a request for compensation related to one or more incidents of sexual abuse and or physical abuse. So I think the way we've defined the term claim as one or more incidents would alleviate, I think, for me at least, the concern that defining physical abuse as a single incident of conduct or sexual abuse as a single incident of conduct, it alleviates the concern that that definition might lead to the thought that you could file 8 claims for 8 incidents. I think one person, one claimant only gets one claim, and that claim may cover multiple incidents, but the way claim is defined, it says one or more. So, I think that if you wanted to say means a single incident or multiple incidents, if you wanted to add or multiple incidents in physical abuse and sexual abuse, I don't see a concern with that. I think it might be extra bootstrapping, but I don't believe it's necessary the way I read the language. I read the intent, and claimants counsel may be able to speak to this, but I read the intent of adding single incident as just trying to confirm that one single incident would be enough to establish physical abuse, or one single incident would be enough to establish sexual abuse. I think the cap language that Representative Lynn mentioned also gets to this concern, because I think that's still, it says $1.5 million for all claims. So even if someone then tried to submit multiple claims based on multiple incidents, it's $1.5 million for all claims. So, or 150 for all, or 150,000 for all physical abuse only claims.
So your position is the definition's fine as is. We don't need to tweak it any further.
That would be my position. Yes.
I'm going to ask Mr. Hayden or Mr. Dean, right? Yeah. To come up in a moment. But Representative Weiler, do you have a question?
So I thought the physical injuries to ones that were dealt with medical care. And, we liable to have somebody come in and say, I was there, the guy named Coach woke me up by slapping me in the face. That's 100 times. We're liable to hear something like that.
Representative, I think to answer that question, I would say I think the intent is to address that in the guidelines. I think whether something required medical care or not would be considered as we craft the guidelines.
So Mr. Tatum, or Hayden, right? Not Tatum. And Mr. Dean, you're welcome to speak. You're not obligated to speak on this. Do you care to speak?
Thank you. I think we agree with Representative Lynn and the Attorney General that no change is needed here. I don't think we ever contemplated that there would be more than one claim filed. I guess I will just state the caution, though, that our clients would be less inclined to use the process where there's some kind of devaluing of subsequent injuries or subsequent abuses. So, when we're talking about somebody that has undergone, abuse a dozen times, severe beatings a dozen times, the thought that, the 12th beating is worth less than the first beating would be problematic. But yes, I mean, I think we're in agreement that each claimant files one claim, and while we don't agree with your caps, we understand that that's where this subcommittee is. So,
Mr. Hatem, do you agree? Yeah, okay. He nods his head yes. Is there any comment from committee members? So I think we can move off. I'm sorry, Representative Mooney.
Thank you, Mr. Chairman. Just to point your attention to page 3, line 25, the frequency and duration of those acts is very clearly stated as part of the formula for valuing claims. So I just wouldn't want that to be in contradiction with the word single on page 1.
I don't know. Since Representative Lynn, do you want to respond to Representative Mooney since you have a mic in front of you?
No, I mean, I agree with, I agree. I think that should address the concerns that, I mean, the point that was raised by council, because I mean, I think this statutory scheme will contemplate that, the frequency of abuse would be a factor that would go into valuing claims, and as it should. I mean, I think that seems to me to be, something that obviously should be the case, and I think we capture it here.
I think we do understand that point, that it would be an aggravating factor, but it does give more discretion to the administrator to vary and potentially to put less value on subsequent harm to somebody. And that's just a concern that we'd like to raise.
I think conceivably it could work the other way too, that there'd be an exponential increase, for each one. But I don't know. I'm not the administrator. We'll go with Representative Rogers and then Representative Leishman.
Yeah, I don't know if this is the time to do this, but I'm going to bring it up. I'm still concerned that the definitions of abuse do not include the emotional abuse, endangerment, the false imprisonment that we talked about the other day. And I didn't know if there was any thought given to including those other types of abuse that we all agree are abuse, but were not put in here. And I guess that would be to Judge Lynn or Attorney Formella.
So I'll ask Attorney General Formella to come up, and we should figure this out so that, because I'm viewing the plaintiff and the Attorney General, you're sort of a team. You're like two sides of the same coin. So bouncing you back and forth, if we could figure out a way, if you're all comfortable sitting near the same table, that would be great. Or whatever you feel comfortable with. We're still in a period of, I think, COVID caution. Do you remember Representative Rogers' comment?
Yes, I believe the question comment was just whether consideration had been given to including things such as emotional abuse, I think the solitary confinement, and other categories of conduct such as that within physical abuse. I guess I would answer that just to say that, kind of going to just echo what I've said before. We have considered that, and we really have thought long and hard about that. We've been thinking about this, not just during the discussions on this bill, but we've had a lot of conversations both internally and with claimants' counsel before the bill ever got introduced. And it's really just a matter of where you cross that threshold to a point where it's just very hard to verify claims. And I think that, emotional abuse for events that took place long ago, these are already it's difficult enough, I think, to go back and kind of suss out what happened with regard to sexual abuse, and even harder with physical abuse. I think once you start getting into things like emotional abuse and intentional infliction of emotional distress, those types of claims arise from actions that, it wouldn't just be about verifying whether the stated actions happened, whether statements were made, but it's also in the eye of the beholder, and it depends on the perspective. The perspective of a resident at YDC may be different than a staff member when it comes to something that could inflict, say, emotional abuse or emotional distress. So we really have thought long and hard about that. From my perspective, it's not a matter of saying that isn't potentially serious conduct or doesn't potentially have a serious impact on a resident. It's just so difficult to go back and really make a determination as to what is or is not emotional abuse, that I think those difficulties warrant leaving it out of the definition for the purpose of a process like this, which is meant to be, very victim-centered and trauma-informed, so not meant to be a really difficult and probing examination of the facts. When it comes to solitary confinement, we do include that as an aggregating factor, but again, the fact is that solitary confinement was an accepted form of punishment, if you will. And I'm not going to make a comment on whether it was a good practice, whether it ever should have been the practice, but it was a common accepted practice. And I think to have this process include claims that don't have physical abuse, don't have sexual abuse, only involve solitary confinement, I think you'd be opening up the process to a lot of former residents that might have gone through YDC, and there might have been a reason they were in solitary confinement. It'd be very difficult to differentiate the impacts among residents. So those are just all the things we've thought about, at least from my perspective as Attorney General in the Department of Justice, when we've thought about whether to include those categories of conduct within physical abuse for purposes of this process, because this is meant to be a trauma-informed process that will not involve very intense probing and examination.
So would you remind the committee that about the due process that we understand was involved in making a solitary confinement decision?
Yeah, so my understanding of how the process would work is that there'd be a committee at the facility that would make determinations on punishment when there were acts committed that might warrant punishment, and that committee would determine whether someone spent time in solitary confinement or not. I will say, I certainly can't comment on whether there were times when a resident was put in solitary confinement without going through that process. I imagine there may have been times when that happened, but those would be difficult to verify and difficult to go back and reconstruct.
Thank you. Representative Rogers, did you have a follow-up?
Well, I just state that I'm concerned that we're leaving some of this out, and especially the solitary confinement. I understand the difficulties, but we've been pointed out instances that were people in solitary confinement for egregious amounts of time, and we've seen studies that also show the effect on a child with this. So while I understand that it's difficult, I just think that we're being very closed-minded, if you will, by not expanding it some. But I'll leave it at that for now.
Do you have a question to add to that follow-up, or is that just your
I would just, ask if in fact it was practice to leave people in there for 6 months, which we have incidences of.
It's hard for me to hear you. I think if you got the mic closer to your mouth, it would
Okay, I
all.
was just, and maybe the attorney, he said that it was common practice, but is it common practice to leave someone in there for 6 months? And I think, the acceptance of it, was that an accepted national standard? Was it an accepted local standard? When we say acceptance, who was it accepted by?
So I think that's a fair question that would be answered in a totally different process than what we're trying to set up here.
Okay.
So, Representative Leishman, I think you were next.
Thanks, Mr. Chairman. Just like to take Representative Mooney's question a little bit further. Again, going to line 27. Is there a need to say single? We've talked about whether it says single or multiple, and just say an incident, period, without saying multiple or single.
The language, I think, originated with the plaintiffs, and so single is in there out of respect for their input, but if either of you have a comment on Representative Leishman's question.
Well, I think it was previously expressed that we do want it to be clear that a single incident is sufficient to bring a claim to the process. We want that clarification.
Okay. Thanks, Mr. Chairman.
I would be happier if it just said an incident, and we made and we struck through single, but that's just me. I hear Representative Weiler just voicing some support for that. Is there any, I hate reopening this up though, so why don't we hang on to that, and maybe we could do it if there's other things that need to open up this with OLS. Did you have a follow-up, Representative Leishman? Okay, Representative Hatch and then Representative Walls.
Question answered. Thank you, Mr. Chair.
Representative Walls.
Yeah, I want to go back and revisit the whole issue of solitary confinement, particularly in light of what our fine Attorney General has said. And, I suspect this actually is one of the areas where there are probably the clearest records, more than sexual abuse or physical abuse. If you put somebody in solitary confinement for a number of months, that probably is still in their record from the time that they were incarcerated. And, I think the question of what was the standard is something that can be answered during the hearings, but it can't be answered if we don't put it in here, if we don't make solitary confinement an issue, not an aggravating factor. And given the data that's out there on the literal destruction of one's brain by being put in solitary confinement, I think it should be a standalone cause, not just a contributing factor. And so I'm a little confused by the suggestion that there isn't information on it, because I suspect there's information on this even more than the other claims. And I'm very concerned that we're taking something that could have been so harmful to these kids and not including it in this. Thank you.
So I'll respond to that, and then Representative Weiler can speak next. My thought on that is that if there was an adjudicated decision to incarcerate or to put somebody in solitary confinement for any period of time, especially if it was an extended period of time, that there probably is a record of that. But the challenge I'm seeing to this, though, is that we're opening up claims that go back as far as possible. And I don't know, I just don't know, I honestly don't know. What is the data retention period for these files? I mean, if at some point some good administrator might have started throwing out files after they were 10, 15 years old, and would we create the presumption of guilt on the part of the state if we can't produce a record because the record was destroyed in sort of the ordinary bookkeeping of records? So I'm sympathetic to solitary confinement being severe abuse, but I don't know how we can expect the state to represent exactly what took place when we're dealing with things so long ago. That's just my That's just my response to what you're thinking. Go ahead.
So I would suggest that issue is going to occur with all these kinds of abuse when you go back far enough. Physical abuse, sexual abuse, and solitary confinement. You're going to be on equal footing for trying to prove or not prove or find records of or not find records of. I think you're more likely to find records of solitary confinement than of anything else. But I think if the claim is old enough, they all could suffer from what you say, and that is a destruction of records. And so I'm not sure why solitary confinement should be treated differently than any other older claim.
Thank you. Representative Weiler?
I'm not in favor of having solitary confinement be something that should be paid as damages. If you've got things to read and you've got homework to do and all that kind of thing, it's almost a welcome sense of privacy and so on. I don't know whether that's available or not. But I also look at the secure housing unit up at the prison where people are in for years, solitary confinement, 23 hours a day, all the time. I don't want to make a precedent saying, oh, that's so damaging that we're going to pay you big bucks, because they'd be lined up at the door. I'm not going to support solitary confinement.
I believe we took a straw vote on this issue 2 days ago, and this is good discussion, but I think it's settled at the committee level. Unless there's anyone who wants another straw vote, we can certainly do that.
I'd like another straw vote.
Representative Weiler requests another straw vote. Again, this is going to be with Division 1 and Division 3 members. If you're on Division 2, please withhold your vote. Representative Umberger, do you have something to say?
Yes, I do. The purpose of this process is to take care of the sexual and physical abuse that occurred at YDC, whatever, Sanudo Center, I don't care where it is. It was not to take care of every ill that might have been perpetrated on a person that is in there. If this doesn't cover whatever it is, the person has the opportunity to go to court. Just like in this process, if you don't like the decision of the AG designee, you can back off and go to court. And so if someone thinks that solitary confinement is, the horrendous problem, and there's nothing else associated with it, then they can go to court. If solitary confinement was part of sexual abuse or physical abuse, and they don't like the AG's designee's decision, they can still go to court. We have opened this up significantly from when we first started, to where you get the first decision, and then you make the decision whether to go to the administrator or to go to court. And so if I just feel that if that's what you want to go after the state for, then you do it through the court system and not through this system, which is to help in some small way for the state to provide recompense for whatever happened in the past. So, thank you.
Thank you. So we're going to have a straw vote. There's going to be 2 opportunities to vote. The first one will be you'll raise your hand if you are in favor of adding solitary confinement to this bill. And the second vote will be if you are opposed to adding solitary confinement to the bill. I'll be voting for the second time. So I'd like to see a show of hands, and Mr. Clerk, if you'll help me count. Raise your hand if you think we should add solitary confinement as a reason in and of itself to file a claim in the statute. In favor is 5, and then please raise your hand if you are opposed to adding solitary confinement. So we have a 5-8 vote, which means that the straw vote failed, and we will not be adding solitary confinement. Okay, I think we'll get through the other pages a little faster. But that was page one, and I think the definitional issues are really key. So I think that was time well spent. There's nothing on, there are no recommended changes on page two, I don't think. Oh, wait a second. Mr. Hoffman, I'll shut up and let you take it.
On page 2, beginning on line 29, this language was changed, and I can read it, or if the committee would prefer not to hear my voice, we can pause and the members can read it however you wish.
I completed reading it, and my lips were moving while I was doing it. So everyone should have read this by now. Mr. Hoffman, do you want to explain to us what we tried to do with this language?
Well, there are a couple pieces here. There's the agreement on the administrator, the appointment of the administrator, and if the Attorney General's designee or the Attorney General and the council don't agree, then the Supreme Court would choose an administrator from a list of candidates, 2 each provided, and then make a decision within 30 days. And then starting at the bottom on line 35, it talks about the compensation of the administrator, whether or not they're full-time or part-time, and how they would be paid.
So I believe we talked about this quite a lot on Tuesday. Is there any new perspectives to be shared? Okay, so let's move on to what Representative Umberger.
I'm sorry. It doesn't seem to say in here when the administrator needs to be appointed. But later on, he has responsibility to do something starting 1 November. And so in other places, we have said the AG will get together and do the guidelines, and we'll do this and do that. But I am concerned that we don't have a timeline for the administrator that says the administrator will be appointed by 1 October or 15 October or 29 October. But it needs to be before the claims can be filed, which is 1 November. Otherwise, we can't get the data out unless I'm missing something someplace. But
Do you think that needs to be incorporated into this document, or that the fact that there's a hiring authority in here, that they have the flexibility to do something rational and hire them in advance of? Do you want it in here?
I have no problem as long as the AG and the plaintiff's counsel recognize that this is something that will have to be done as a first step, I think.
Do either of you want to comment on this? And by either, I mean the two of you are one. So,
Yeah, I think the way I look at it is, given that the deadline to kick off the process by publishing notice is November 1, I think that kind of provides a deadline to get the guidelines negotiated and approved, and then the administrator appointed in time to meet that November 1 deadline of publishing notice and kicking everything off. So I think there is a deadline in here, and I think we would know that we've got to get things done quickly enough so that we can ultimately meet that November 1st deadline.
So, from our standpoint, this process, once the guidelines have been established, can't happen fast enough for us. So we have every incentive to get past the guidelines as well as pick an administrator in a timely fashion. So I don't see that a deadline's necessary.
All right, so I'd really like to not open this document back up, and so I'm not seeing a compelling reason to do that.
Thank you. I'm not excited about that either.
Okay. I'm glad we share a common sense of apathy about that. All right, so Mr. Hoffman, I think we're on page 3, line 18.
Can I make a comment?
Wait a second, Representative Emmerich?
I just wanted to comment, this says per diem. The state per diem is 7.5 hours. Is that correct?
For the majority of classified employees, it is 37 and a half hours. There are different jobs that are 40-hour work weeks.
Okay, I don't have a dog in the hunt here. I'm just saying, is it which part of the state's per diem hourly day are we going to use?
What line are you on?
Page 3, line 2, 1 and 2.
So he's just questioning what the definition of per diem is in this context. Is it 37 and a half hours, or I would have assumed it was 40.
I would assume an 8-hour day, but I just wanted to throw it out there, just to make everybody upset.
So, you're taxing my memory on this a little bit, but I think that the way the judicial branch would consider the per diem rate for let's say a Superior Court judge, I think that they would say, these are the work days during the year. And, so in other words, it wouldn't include weekends, it wouldn't include holidays, whatever that, 365 minus those days are the work days during the year. And then I believe they divide that by the judge's yearly salary and say that's the per diem rate for a judge for a day. And so I assume that's the way they would do it. That's the way they would interpret this to me.
Okay, is there anyone on the committee that doesn't want it to be assumed to be an 8-hour day? What's our intent here? We want it to be an 8-hour day, right? Anyone? Yes. So I don't know if we need to open up the language to that. No?
Yeah, I don't think so, just because it says it no more than, I don't think.
Okay, so I was talking, we decided to do nothing about that. So page 3, line 18, Mr. Hoffman?
Yes, the work group modified this language to read, the Attorney General, after making good faith efforts to reach agreements with the claimant's counsel and with input from the Attorney General's victim witness advocates, shall develop and present the claims process. So I think the shaded language was changed from what was in the original bill, and I'm not sure how that ties in with the plaintiff attorney's suggestion.
So the point here was we just wanted to make sure there was a line of accountability, and the prior writing was a joint responsibility between plaintiffs and the Attorney General. So I think this language achieves what we said we wanted to do 2 days ago. Is there any disagreement on that? Do we want to open this up for more discussion or move on? I'm not seeing anyone wanting to talk further about this. So let's go down to line, whatever that is, 30?
bottom of the page is shaded to indicate that there was a suggestion by plaintiff's counsel to have the appointment of a mediator to resolve disputes, and that language was not adopted.
Again, I think we talked about this 2 days ago, and this is consistent with the straw votes. Is there any new information or new perspectives to share? I'm not seeing any, so Mr. Hoffman, would you take us to the next item, please?
Next item is on page 4, starting on line 9, and it reads, "For all claims involving both sexual and physical abuse or sexual abuse only, no individual claimant shall be paid more than $1,500,000 in settlement of all claims in the aggregate. For claims involving physical abuse only, no individual claimant shall be paid more than $150,000 in settlement of all physical abuse claims in the aggregate."
So I have a math question to ask the Attorney General. If
That's dangerous.
Yeah, if somebody came in and their violation was so grievous on the sexual abuse area and they got the 1.5 million, but then they had a standalone set of physical abuse only claims, would the total amount that they could be compensated be the 1.5 million or 1.65 million? Because you would take the two caps and add them potentially.
Yeah, I think the total would be 1.5 million, because the 1.5 million is the cap for all claims. The 150,000 is meant to just apply to all physical abuse only claims, or all physical abuse claims. So the $150,000 cap is really just meant to apply to that claimant who comes forward with only physical abuse claims.
Is there anyone else with a question on that? I'm not seeing any. Mr. Hoffman, would you go down to line 34? Oh, wait. I don't do that on purpose. It's
Oh, no,
just,
I didn't think you did. You
it's
just
hard to
assumed.
see you back there. So Representative Rogers, please go ahead.
Yeah, I know we talked about it the other day, and you don't want to reopen it, but my concern here is that this is going to be a reason for the plaintiffs not to come forward and go through the settlement process, and instead going to court. We do know that there was an average taken, but average doesn't really reflect in a situation like this. There have been much larger settlements, there have been smaller around the country for similar kind of things. And I'm just asking the Attorney General, is there a reason you don't share any concern that I know we wanted to get as many people to go through this process as possible. And recently we found in some of the more infamous cases around the country of this kind of thing have been much larger agreements or settlements. And my concern again is that for trying to do an average, because as I said, averages on this, you can take an average, but each case is different, each document is different, each person is different, so I don't think an average really reflects. So you don't have any concern that people are not going to go forward because of the fact that we've capped the award level?
Yeah, thank you, Representative. I think the first point I would say in response is that the average that we identified, if you'll recall, but I know it was a few meetings ago, was somewhere between $500,000 and $550,000 per claimant. That was the average we identified when we looked at past verdicts and settlements. So this cap of 1.5 million, just to start, it's quite a bit higher than even that national average we identified. I think our goal would be to, through the development of the guidelines, design a process where our average fell, roughly within that range, so not too much higher than 500 to 550,000, what each claimant would end up getting at the end of the day. But this cap does provide room for a payment to an individual claimant of of significantly over the national average that we identified, at least for claims that involve sexual and physical abuse. And as I mentioned, I think last time, based on our research, you know, the average for physical abuse claims we identified was between $65,000 and $75,000 per claimant. So the $150,000 cap does allow for going, you know, significantly above that, and for particular claims within this process. So I would just note that as a first point in response to your concern. The second point you raise, it's a fair one and it's a good one. And I think, yes, I have thought about the fact that by having a cap of 1.5 million for all claims, $150,000 for physical abuse claims, I think there is a possibility, and it's probably almost a certainty, that there will be some claimants who feel they have a case, or who have been harmed, who have suffered abuse, who might feel that they have a case that's worth more than these caps, and they may decide to go to court. I think that's okay. I mean, I think our goal has been to provide an alternative process that offers a quicker and smoother path to resolution. The trade-off being, in some cases, it may be less money than you could expect if you go to court. I would expect that most will take that option, but I've always had the expectation, and I think we all, I don't want to speak for everyone here, but I think we all do, I've always had the expectation that there may be a small percentage who would not elect that option. So it really is a balance between trying to encourage as many claimants as possible to come through the process, but to keep the numbers at a level that's appropriate for a process that doesn't involve the same type of intense litigation and verification and investigation that traditional litigation would. If you go through the traditional litigation process, you have a fully litigated, fully discovered case. By the end of it, even if the number's big, you can be more confident, I think, that you've really gotten to what I'll just say, you know, you've gotten to the truth. The goal of this process is, yes, to get to the truth, but the primary goal is to create a smooth and efficient process that is fair to claimants and gets them compensation for harm. So all that said, I apologize for the long answer, but I just want to give you a sense again of my thinking on this. So those are the factors that went into it. The concern you raise, yes, it's on our mind, but we have to balance that concern with making sure these values are appropriate for a process like this.
Follow-up?
Yeah, I have the I'll ask them both right now so you can do it. The two questions I have for you is, what would be the average, is that word again, average, but the cost to your office in litigating a fairly complicated case like one of these? And secondly, do you foresee the administrator ever saying to someone that comes forward with a particularly egregious event, saying, you really should go to court because we're not going to be able to obligate, you know, to deal with this way because of the cap and so forth. If it's something particularly, you know, that any of us would look at it and say, this should get more. And I think you're looking at me like I'm crazy about the time. I'm just curious. I mean, I've administered a legal office before, and I know there's different ways to break out. But I'm just curious, what per case, when you prosecute these cases, how many attorneys, how long of their time, and what kind of cost is there to the office? And when I say cost, I don't mean just the monetary.
Yep. No, and trust me, I'm not looking at you like you're crazy, just kind of thinking as you talk. And so if any facial expressions are more just trying to think about the response.
Oh, everybody thinks I'm crazy, so don't worry about it.
So the first question, what's the average cost? That's difficult to pinpoint. It's very rare that even when these cases do go to court, that they end up going all the way through trial and they get to a verdict. But what might happen when you go to court is that you at least get further through discovery, you get closer to perhaps dispositive motions, and you get to a point where you're more comfortable that each side has the information they need to have in order to engage in settlement discussions. I think on a case like this, if we were just to take one claimant, probably involves a couple of attorneys in our office and I don't have a good sense of how much of their time it would take. It really, it's a case-by-case basis. It just depends on how many records are available, how burdensome the discovery is. But every attorney in our litigation unit carries a very heavy caseload. And even a case like this, it's just, and I don't mean to, by saying it's just one more case, I don't mean to discount that, but it's another case in their caseload. So it's very hard to pinpoint what the costs either are in dollars or attorney time for a case, because it just depends. But a case like this, it's not insignificant. I just don't have an estimate for you.
So we've had a similar conversation every hearing, and the way I summarize what I think we're doing here is the Attorney General and his team has undergone a data-driven process to get as much information as they can to inform them, knowing that this is something that we've never done before. And so ultimately, this is, I think, is going to rely on just best judgment and the humility that we might be wrong, but we're trying to get it as right as we can. That's my take. And I see you shaking your head, yes, so I won't go to you. But Representative Umberger?
Yes, this is to answer part of one of Representative Rogers' questions. She said, would the administrator ever tell a person to go to court? Well, the bottom line is that it would never get to the administrator for that decision, because the decision needs to be made at the AG designee level. And so if they decide not to go to court, then the administrator is really not involved. So, thank you.
Representative Weiler?
Let's not lose sight of the fact that it's an experimental process which never been done before. We're trying to deal with hundreds of cases, trying to minimize the amount of time that would take to settle them. And some of these people are willing to settle for a lot less than we think. And the idea is to find those and get those cases out of the way. Obviously, we know from the beginning that many will want to go to court. The first few, it may take 3 or 4 years before they get there. And then they might have a jury that decides you're getting 0. There's always that chance. So at least by going through this process, it's likely you'll get some money. So I think a lot of people will look at the odds and say, well, I want money now. And they're just going to go ahead with this process as proposed and not dream of becoming an instant millionaire because they're going to court. I don't think that will happen. I think the first 1 or 2 that go all the way to court are going to be sadly disappointed. Thank you.
All right, I didn't hear a question in there, so I think we're getting ready to move on. Just for situational awareness, the House Republicans started their decorum meeting at 3 p.m., and so for those of you that are missing it, I will give you constructive credit for that as long as you behave, so. So, Mr. Hoffman, would you take us to line 13?
Yes, line 13, you'll see the shaded November 1st, 2022. That used to read December 1st, 2022. Provides 1 extra month on earlier publication of notice. So happens a little sooner.
All right, I'm not seeing any conversation there. Do you want to go to 34, line 34?
Line 34 was added to read, once a claim has been properly filed by a living former YDC resident, the subsequent death of that claimant shall not extinguish the claim.
I think we had a good conversation 2 days ago on that, and that seems to hit what we said. Is there any discussion on that? I'm not seeing any. So if you would take us to page 5, line 8.
The language here was revised to read, by filing a claim, the claimant agrees that he or she will participate in the claims process, and if the claimant requests that the administrator decide the claim, agrees to accept the determination of the administrator as final and binding, even if the claimant does not receive any payment from the fund.
Okay, so in the past, when we've discussed this section, I wanted to be sensitive to whether or not the plaintiffs read this language and can accept this. Is this acceptable to you, the way this is framed?
So we believe this is stated properly and consistent with what, you know, the way this bill is constructed. So yes, we're fine with it.
All right, thank you. If there's no further discussion or questions, let's go down to line 33, Mr. Hoffman.
Line 33 is added reference to the right to know statute 91A, and that ties in with discussion later on toward the end of the amendment regarding the right to know information.
All right, so let's defer if there are any questions on that to the other bigger discussion. So I think we're on line 6, or excuse me, page 6, line 17.
This language was added starting on 17. Would you like me to read it or give everyone a chance to read it?
B, let's go ahead and read it individually. I still see people reading, so. Can you add some context of what the work group attempted to do with this section?
I would defer to the main participants of the work group.
Mr. Attorney General?
Yeah, this language was added. It actually mirrors language that appears later in the bill, but as we were going through the bill yesterday, I realized that while later in the bill there's language regarding advising the claimant of their options and then giving the claimant a certain amount of time to indicate their response to the AG designee's position. That language came after a claim was referred to an investigator. We didn't have language to address what happens for claims that aren't referred to an investigator. So I just thought we should add the same language to apply, so it applies to claims that are never referred to an investigator in the first place.
So Mr. Hayden or Dean, do you have any comment on this?
I'm going to take credit for raising this issue last Tuesday, and I'm going to give the Attorney General credit for properly wording it in this amendment.
All right, success. Very nice. So let's go to page 7, line 8, Mr. Hoffman.
Line 8 clarifies that the claimant will be advised in writing, and then at the end, instead of withdrawing his or her claim, it adds from further processing.
Any comment, question on that? I'm not seeing any. Do you want to go to line 13, please?
There is one more note on that last one that I missed. The work group removed a sentence stating that an explanation shall be provided of how the attorney's fees are impacted by resolution process. And that was determined to be unnecessary because of the change to the cap on legal fees.
Just, would you stick my nose into where the 33 1/3%, what part of the bill is that on? Are we going to be reading that later on? So I'll ask that question later.
Yes, it is on page 9, though.
All right. Okay, so we opened up line 8 and 10. I don't think we have any comments on those. Do we want to go, are you ready for line 13?
Yes. That should probably be, all of subsection H should probably be read together with the changes. Within 30 days of receiving the updated position of the AG designee, the claimant shall indicate to the administrator and the AG designee whether he or she agrees with the AG designee's position, whether he or she wishes for the administrator to decide the claim, or whether he or she wishes to withdraw the claim from further processing. In the absence of an indication from the claimant, the administrator may assume that the claimant is in agreement with the position of the AG designee. If the claimant and the AG designee are in agreement regarding the disposition of the claim, the administrator shall make an award consistent with the parties' agreement.
Does anyone have a question or comment on that section, section H? Is everyone getting enough time to actually have an opportunity to speak up if they see something? Because I am trying to move through this, but I don't want to override anyone's speaking. I think we're on page 8, and we're down to line 17.
There was another recommendation in the margin next to line 18 on page 7, that the work group opted not to include language making the claimant aware in writing of his or her options. And the reason for that is the issue was addressed elsewhere in the bill.
When you say elsewhere, is it to come still, or did we cover that part of the bill?
It was addressed on page 7, line 8. And
Okay. Thank you. So I believe we're on page 9, line 9.
I think we have a change on page 8 at line 17.
Oh, I thought we just did that. Go ahead. Thanks for the catch.
This has to do with the situation where there may have been a mathematical error, miscalculation. It provides that the claimant or the AG designee may request the administrator to reconsider decision based on mathematical mistakes or miscalculations.
Okay. Plaintiffs, do you have a comment or concern or anything you want to talk about here?
That change is fine.
Thank you. Any other comments, questions? So now we're at 9.9. I sound like a German.
9.9, that's the language that deals with the attorney's fees, and it reads, the administrator shall not approve any request of an attorney fee or costs which are not reasonable. The administrator shall not approve an attorney's fee in excess of 33 1/3% of the amount of the award. All costs and attorney fees paid to a claimant, its attorney shall be paid from the amount awarded to the claimant.
All right. I think we talked about that a good deal Tuesday, and this is consistent with what we agreed on then. So, does anyone have any new comment or consideration to throw in here? Representative Weiler, did you have something you wanted to say, sir?
I just said we agreed to eliminate 25% and Judge Lynn's recommendation, make it all 33 1/3, so there was no incentive to go beyond the first step. Thank you.
As I understand it, it's a little more nuanced than that. The 33 1/3% gets to be the ceiling, and the administrator could choose a lower contingency fee depending on what's reasonable.
Exactly. Yes. The 33 1/3 is is the maximum.
Thank you. Okay, so let's drop down to line 25. I think it's 20.
And this is the language that concerned with the right to know information. The shaded language was agreed to by the committee on Tuesday. And the new language reads, records of the Youth Development Center claims administration in the YDC Settlement Fund pursuant to RSA 21M:11-A, with the exception of settlement agreements which shall remain subject to right to know. And after a claim has been finally resolved, such other records, the release of which would not constitute a violation of the provisions of law or an unwanted invasion of a claimant's privacy. And the section being amended there are the exemptions to the right to know law.
So I think this is consistent with what we talked about on Tuesday, and I'm just curious, this is more trivia than essential, but since we've drafted this particular version, has anyone heard from the union leader or Ms. Timmons who spoke on this? Okay, we haven't gotten feedback. This represents to me a good faith effort to address the concerns of the media. I may be wrong, I'm not a lawyer. So let's go to line 35. I'm sorry, Representative Wallner, I didn't see you. Go ahead.
Even though I know that there's going to be no change here, we now hit the appropriations line, and I know that's not red, it's not going to be changed. We agreed upon it, but last time you brought in the amendment, you brought in to take it from the rainy day fund. And I just want to remind everybody that there is a very specific way that you go into the rainy day fund, and I think it's really irresponsible of us as the finance committee to have a bill we're presenting to the legislature that spends $100 million without people understanding that we're bypassing the law that governs the rainy day fund. And so I have a copy of the rainy day fund law for everyone so that they can review it and we can be certain we understand clearly what we're doing. It's really a serious situation because taking money from the rainy day fund will affect our bond rating, or may affect our bond rating, which is going to be a problem in the future. So I think, yeah, I have a copy for everyone, and I think it's just something that we should be sure that people understand what they're doing when we're on the floor with this bill.
I appreciate what you're saying, and as a relatively junior member of this committee, I want to hear from people with more seniority than I have. So, Representative Leishman, is your hand up? Is it, or you just, no, not yet? Representative Emmerich, Representative Weiler, Representative Umberger, do you have anything to say here?
I would just say that before I made the decision to take it from the rainy day fund, I did look at the requirements. I'm well aware of them, and I won't argue with you that it's difficult. And I also know that Neil Kirk is probably standing right behind me with a big fat bat. And
No kidding.
yeah.
This is where I learned this.
And, and I won't deny that. But I also know that our rainy day fund is higher than it's ever been by about $100 million. And so that's where, all that stuff together pointed here. Now, we can also, make the assumption that our revenues from 23 and the lapses that occur will be more than the $100 million. And so, I guess it's a flip of a coin as to what we do. I don't think any of us, no matter how long you've been in the legislature, have ever been in a position where there is this much money out there. And that's not including all the ARPA and the CARES and all that other stuff that we've been dealing with. This is just, state revenue that I haven't been here forever, but I know some of you have, and that's probably the wrong thing to say. Have been here a lot longer than I have. And it's just absolutely unprecedented. So that's.
And I would agree. May I speak?
Go ahead.
Sorry about that. I would agree that it is the most money probably I've ever seen flowing into the state. But the time will come when all this ARPA money, CARES money, all that will dry up. And we will be back again to being dependent on our own resources. And if the time comes when New Hampshire has a financial problem and we have drained the rainy day fund or we have taken a significant amount out, then we will be facing a financial problem. And I just think it's something to take very seriously by the members of the Finance Committee. And I will tell you, I learned this from a member of your party who really understood this very well and taught me many times about the importance of the rainy day fund. So just, I do want to pass the law out, and you've probably all seen it and looked at it, but you'll have your own personal copy, and you can just bring it out and take a look at it before you go to bed at night.
Thank you, Representative Weiler.
Thank you, Mr. Chairman. I've sat in this committee for more than a dozen budgets. I've seen the rainy day fund go up and down, and I've seen many administrations that as soon as they started the budget process, they took almost everything out of the rainy day fund. That's not uncommon. I think this is a good idea because of what we heard in discussions from Ways and Means telling us there's $200 million that we're counting as revenue that is as a result of payroll protection plan that we're forgiving the taxes on, as well as credit carry forward that's getting up over about 100 million. So there's what we think of 200 million that we have in revenue is somebody else's money that we're going to likely have to pay back. We don't know when or over what period of time, but when they brought that out to my attention, I thought, whoa, we're not nearly as far ahead of this revenue as we thought we were. So it's not unusual for us to use rainy day fund. Usually it doesn't go into the middle of the budget, but too often it started the budget by grabbing that money right away. So it's not unusual for money to go in and out of the rainy day fund. And it's unusual for it to come out in the middle, but I think it's happened before when we had a mistake on the revenue. Thank you.
So I have a question, and maybe this is for you, Representative Umberger. As I understand the core of your position, it's like the rainy day fund is an empty coffee can, and we're going to open the bottom of it to pull the 100 million out of this, but at the same time we've got a spigot putting the 100 million into the top of the can. So net, it's no effect on the rainy day fund. Is that a fair interpretation?
The spigot doesn't open until June of '23, at the end of the biennium. So between whenever this passes and the money comes out, the rainy day fund would be short $100 million, or not short, would be $100 million less. Okay?
It would be 100 million less, but then we're anticipating 100 million more flowing to the rainy day fund. I'm just trying to understand
It's,
what
you know,
you've said.
Yeah, a lot, all I can say is a lot depends on how much of the 200 and, can't remember the number, 200 plus million that is currently in bills that are sitting here in finance, how much of that goes. So as to how much is actually in the, I'll call it revenue above projections. So, but yes, and of course what's not included in that are the lapses. And I think all of us know, at least on the fiscal committee, we got a list of all the vacancies that are out there. And I mean, there are hundreds of them. And that's all going to lapse in, at the end of this year. So, I mean, it's, it's a crapshoot, and I'm not very good at craps.
I wouldn't want to interpret this as a gamble. I would say that this is, you're considering the risks. There is some risk to lower revenues than what we're seeing now over the final 16 months of the fiscal year, but that based on lapses and your judgment and experience, we're going to be ending up putting the 100 million back in that we're pulling out here, right? Is it? Again, I'm not trying to put words in your mouth. I'm just trying to protect you from the media.
Yeah. I think that's a fair statement.
Okay, so Representative, I didn't mean to cut you off. Representative Walls, and then we'll go to, was that you, Representative Griffin? Yeah, and then Representative Hatch. Go ahead, Representative Walls.
I just have a question for our esteemed chairman here, and that is, have you talked to the treasurer about what it's going to mean on the bonds or anything else the state is doing to drop this by 100 and then anticipate putting the other 100 in, but how the market's going to look at it and how are they going to react? What's that going to do to the state?
Nothing. We did, I don't remember when it was, Ken, that we had the conversation with the treasurer, not about this particular dollar figure, but about whether or not the amount of money in the rainy day fund made a difference in our bond rating and so on. And I think she said it was kind of a wash.
That's consistent with the conversations I've had with the treasurer on Ways and Means. The rainy day fund is a factor that the bond experts look at, but they're looking more at the aggregate on the overall management and position of the state. And so, although the rainy day fund is a factor, it's not a particularly significant one. And so when we raised the amount that we were going to put in, I was told that it probably would not have a positive effect on our bond rating. So, Representative Griffin?
On the same subject, I'd like to point out that when they do the bond rating, they consider all the liabilities the state may have, not just the balance sheet liabilities. They look at the footnotes and they look at the potential suits against the state. And this takes one of those potential suits and lowers the impact of it.
Thank you for that. Was that you, Representative Hatch, that had your hand
I
up?
just, I hesitate to mention this, but I'm having a little flashback, and I'm thinking about 2008, the last time we had to use the rainy day fund. We were in a very similar circumstance, talking about our finances a year prior to that, or a year and a half prior to that. And then when everything fell out of the bottom, the rainy day fund was woefully short of what we needed to operate the state as it was being operated. We had to make draconian cuts. And our salvation then, though, was in part the tremendous amount of aid we got from the federal government, the next biennium. And I'm just concerned, and maybe we ought to consider the fact that I'm not sure that same level of aid and rescue will be there for us when the stuff hits the fan this time. And I'm just concerned that it may be sooner than later. That's, and I'm not a defender of the rainy day fund by most means, but I am now concerned, and I don't think we're in quite a rosy state as we think we may be, just based on what has happened previously. That's all. Thank you, Mr. Chair.
I'd like to ask you a question, and then we'll go to Representative Weiler. And would it be your position that we should defer funding this until the next fiscal year, and we just put it straight out into the budget? And I'll ask the same question to Representative Wallner.
Not in the least. I think based on the revenues that are coming in, and what we have now, we may very well be able to fund this without a heavy reliance upon the rainy day fund. That's the only thing. And I just learned from Neil Kirk also, and that's the last gap effort, the rainy day fund. I mean, he is standing with that baseball bat. I can see his shadow right now, but it's just, it concerns me. That's all. Not a criticism or anything else. I'm just thinking back to what occurred not too many years ago. Thank you.
Thank you. Representative Wallner, do you want to respond to my question?
I think the way the bill was drafted in this section from at the beginning was the correct way to do it. Take it from the general fund. We know now that right now that our revenues are coming in stronger. I heard the reason that we want to take it from the rainy day fund is because, let's see if I can come up with how to describe this. The reason we want to take it from the rainy day fund is that it's like if I got a raise at work and I decided I'm going to spend all that, oh boy, I'm going to spend all that, and I'm still going to go over here in my savings account and I'm going to take out enough money to buy myself a new car. That's what we're doing. So we want to spend all the revenue that's coming in. That was the answer I had the first time I asked the question. We anticipate all the bills that are coming, and we want to spend all of those, and we want to spend from our savings account. I think it's just to think about. And we are the Finance Committee, and we should think about this and make sure we are clear with what we're doing. And I'm most concerned that we be clear with the full House when we're on the floor, that they understand that what they're doing.
I agree with the transparency. Last or 2 days ago, or maybe it was a previous one, I rationalized this without being an expert in the rainy day fund law, that going back to 1990 and even earlier, we were accruing unseen liabilities over all of that course of time. So we are now recognizing that we've accrued decades of liability. The money that's in the rainy day fund has also accumulated over some number of years. And I see some logic on looking at this kind of from an accrual perspective, is that we should try to match the accrued revenues with the accrued liabilities. Is that argument persuasive in the least with you?
I don't think you have to persuade me. You have to persuade the other 400 people on the floor.
But your opinion matters more to me than theirs. So I am asking you, is that at all a persuasive argument for you?
No, not really.
All right, thank you. Representative Weiler?
Big picture numbers. Biennium budget, $13 billion. 1/3 of that roughly is going to employee wages and benefits. That's about $4 billion. When we looked in Division 3 at the HHS and we found they were short 1,000 employees, that allowed us to take 70 million virtually out of that HHS budget, which balanced the budget. We were 70 million short of what HHS told us. if we have 3,000 vacancies, which is likely what we're hearing, that's going to be 3 times that. So if we were able to get that much money from vacancies, 70 million, and so it's, say it's 3 times that, that's almost 2 billion. So, you know, I'm not worried about, as the chairman pointed out, when we look at all the lapses, it's going to be big money. And, you know, that's money that we put in a budget that will not be spent. So it's going to lapse. There's no other place for it to go. And we're still functioning, even short of people as we are. Thank you.
Representative Leishman?
Thank you, Mr. Chairman. So I sat next to Neil Kirk in Division One. I sat next to Neil in the full committee. We used to call him Mr. Neil, but I look at this situation. First of all, I'm disgusted with what happened, whether it be at the Sununu Center or elsewhere. And I share the same concerns as my colleagues behind me and in front of me and to the side as far as where the money is coming from. But I think if it comes from the rainy day fund, in my particular viewpoint, that sends a good message because we know the money is there. And where, you know, as Representative Weiler said, we heard a week or so ago in fiscal, we have perhaps as many as 3,000 vacancies in state government, but we don't know what can happen in the next 15 or 16 months. But at least with the rainy day fund, right now it stands at about $256 million. And to me, knowing that that money is there and would be guaranteed to whatever settlements that may be forthcoming, those individuals out there know the state's word is there because the money is there. So I'll support it coming out of the rainy day fund.
So I don't see a need for a straw vote on this because we'd already had accepted it, but I'll entertain if somebody wants to have a straw vote on this. All right. I think it was a good conversation. I learned something. I learned I need to do better to persuade you in the future, so that's good. So, oh, yeah, Representative Walz, please.
Thank you. I just have a comment that I find it ironic that the so-called tax and spend Democrats are the ones that don't want to spend the extra $100 million. And the other side of the aisle is when advocating spending $100 million. It's an unusual role reversal that I just want to bring to people's attention that we seem to be the frugal ones this time.
As I understand Representative Weiler's comments, in the past, the yin and the yang have been backwards, and the Blue Party took from the rainy day fund to fund their budget plans at the outset. So it isn't that we're so different, it's just our timing is different. But Representative Umberger?
Yeah, I hope that from that comment, Representative Walz, that you don't mean that we shouldn't pass this bill. Okay. All right, thank you, because it...
My only reference is whether we raid the rainy day fund so that we can spend the full $250 million in surplus, or we pull this out of the surplus so we spend less of the surplus and maintain the rainy day fund. Absolutely, we should fund this. The question only is, where do we take it from?
I got it. Okay, but that was not how it sounded. So, thank you.
All right. I think we're ready to move on. Do you remember where we are? We took a side track, but it was a good one. Are we on line 25 or lower?
35. We're on the last change, and this is the sunset language. We asked OLS to provide language to repeal the law, either on termination of the fund on June 30th, 2032, or when it's determined that the fund is no longer needed, as stated on page 2. So this repeal language would repeal all of this new statute and the change to the right to know law.
Okay, so much of this is the first time we're reading the repeal language, so let's take a moment to make sure everyone's had a chance to read it. Representative Lynn, do you have a comment?
You know, I really just have a question, and I'm frankly not sure of the answer, but I raise the question. I have no problem with the sunset provision with regard to Section 2. I just have a question about, is there really a reason to repeal Section 3? I mean, I understand that once this whole claims process is done, it will be unlikely that somebody would make a request to get access to records, you know, after that time as opposed to earlier, but maybe, you know, I mean, what if in 2035, after this is all resolved, somebody wants to get access to some records of a settlement or something about a settlement that happened in 2025, wouldn't you want the same law as to right to know access to be in existence? And so that's my only question.
Personally, I agree with that concern completely. Just reading it, I can't tell if that portion, the right to know portion, is repealed at the same time. Is it?
I think it is. If I read the language correctly, I think it is. It says that Section 2, which is basically the bulk of the bill, and the RSA 91A513, which is what we've added in Section 3, shall be repealed. So I think it does apply to both.
Comment?
This is an experimental program. Looking at it that way, did it work? Some years later, we'll decide, did it work? Was it a good thing we did? If it did, then we may want to revitalize what we did before, and it will still be available. But I don't know if we want to take a different approach, because there are things in here that are unique, and I thought I considered this one of them. So, you know, after we can evaluate when this is all said and done, if something comes up again, would we revisit this process? And it would always be available to put the same language back in another bill, because it would be a whole, I'm sure that once we do another process, we'll say, we should have changed this, we should have changed that. Going back over it, there will be changes. So looking at this as an experimental process, I'm sure that I can figure out whether we did the right thing or not by repealing that which we created. Thank you.
So Representative Lynn, I'm gonna go with your instinct on this and think that maybe the repeal needs to be tweaked so that the right to know language lives beyond for these records. Do you think, what's your legislative opinion? Should we reopen this with OLS to tweak the language, or should we go ahead and take a vote on this total bill and pass it to full finance? And while you think of that answer, I'll go to Mr. Hatem.
I think there's a other dimension to this question that really should be considered. And, you know, I generally agree with the statement that, you know, this fund and this process was expected to be around until it was no longer needed. The issue is that those words don't actually exist in this bill. And, you know, in going back to page 3, it just says, unless early discontinued by the Attorney General in consultation with the administrator. So when you tie that to the repeal of the process, it sort of seems like there's no restrictions on the Attorney General's authority to effectively ask for, you know, the termination of the fund and the repeal of the law. So, you know, I don't think that's what anyone intends, but I think that's the way the words could be read.
So I think I've been maybe the loudest advocate for a sunset provision on this, and maybe I'm wrong. Would it just be better to strike all of the repeal language, knowing we got 10 years to get it right? Go ahead, Mr. Attorney General.
Yeah, I mean, the more I've thought about this, the more I think it's probably better to let the legislature just repeal this 10 years from now or whatever I mean, the legislature's done that before, where it will just repeal something once the time comes to repeal it. I think that's another way to handle this. And I've wrestled with whether there are other provisions of the bill that really need to stay in place. I think they probably don't, but the safer course of action, given the concern raised with the 91A provision, may just be to take this section out and rely on whoever's in the legislature 10 years from now to repeal it when the time comes. But
So
that's
Representative
my view.
Umberger, are you going to remember to repeal this in 10 years?
Absolutely.
So,
I'll put it on my calendar.
okay, so Representative Lynn, I did say I'd come back to you for your thoughts on this. What do you think?
You know, I think I agree with Representative Umberger and the Attorney General that that seems like a better, you know, maybe we could, the Attorney General is required to give reports periodically, you know, maybe on the last report, so to speak, he might say, and by the way, you folks in the legislature may want to consider repealing this now that it's all over. And by that point, we'll have had all the experience with the operation of it, so that if there are other provisions besides the right to know law that should be kept in effect or something, he can make that recommendation to us.
All right. I don't want to fall on that sword. I just like the idea, the concept of cleaning up after ourselves. If we know this is a temporary project that's going to end, I just like having it have the garbage take itself out, but it seems like the cleanest thing to do at this point would be to repeal it. If we're going to open this back up to OLS, I would like to go back to page 1 and strike the word single that's used on line
Mr. Chairman?
27 and line 30. And who said that?
I did.
Representative Irf.
So before we leave that, just so I understand, back on page 2, line 18, if I read that correctly, the fund ends on June 30th, 2032. Is that not correct? So why wouldn't we just repeal it on June 30th, 2032?
I think what we're noticing is that there may still be public interest in the records, and the right to know provisions ought to survive, because in particular, we are tweaking 91A a little bit in this bill.
Okay, fair enough. So leave that if that's important, but why not get rid of the other parts and let the money go back to the stabilization fund? Not if it's not terminated.
Representative Umberger?
This is not, has no effect on our previous statement that it's going to lapse to the rainy day fund in 2032.
Yeah, no, I understand. That's what I'm reading. So we still need section 2 of the bill after that point, which is basically the majority of the bill, except for the RSA,
So just, I'm a little confused. So please help me. Page 9, line 35, where we start the repeal section, the sunset provision, are
you asking me?
you taking issue on whether or not we should delete that paragraph 5 on repeal, the whole paragraph?
I'm asking about sort of the other half of what you were worried about. You want the RSA 91A stuff left in there, as I understand it, and I'm not quibbling that. I'm just still wondering why the other part needs to remain. Section 2.
It doesn't.
We're not touching section 2. We're just,
No.
If I'm not mistaken, the repeals sections 2 and section 3. Am I not reading that correctly?
That's correct.
So
yeah, but we're saying we would repeal those as needed.
You want section 3. I get it. But do you want section 2? Why is that not being, why would we not repeal that? Is my question to the AG, I guess.
There are a number of provisions I think in all of section 2 that one might argue should stay in place. There's a provision in there that talks about the fact that the publication of notice, is also constitutes notice for purposes of sort of beginning or cutting off any tolling of the statute of limitations. So once that notice is published, there's no doubt that the 3-year statute of limitations starts to run for any claims. There's just some other provisions in there, I think, that some may feel like should stay around so people can look back and see in the RSAs that this happened. That said, I also don't have a huge concern with the bill with the sunset provision. I think my thought was just it's probably safer not to sunset it. With that, I do apologize, Mr. Chair. I need to leave. I have to go back to the office for something.
I think we're really close.
Okay.
So I appreciate everything you've done on this.
Yep.
So thanks.
Yep, thank you. Thank you all.
Thank you, John.
So, okay, so Representative Irf, I just
If
hate
he's
the
leaving, I'll drop
idea.
it.
I'm sorry?
If he's leaving, I'll drop it. My last question would have been for him, so.
Oh,
I know.
Okay, I just want to explain myself and why I think just deleting paragraph 5, starting on line 35 and running to the next page 10, going through line 4, just removing that is just the cleanest way to make sure that we don't accidentally break something here. I hate doing legislation on the fly in a committee like this. So, and I am trying to move us towards a vote so we can get this to the Finance Committee. So I think we need to have a clean motion. All right. So we'll do a straw vote on this. I like this amendment a lot, but I think we've had a conversation about starting at page 9, line 35, where it's section 5 on repeal begins, and then ends on page 10, line 4. I'd like to take a straw poll to see who would be in favor of removing that section. And then the other vote would be who is in favor of keeping it. So does everyone understand what the straw vote's going to be? Raise your hand if you think we should delete section 5 or paragraph 5 on repeal.
1, 2, 3, 4, 5, 6, 7.
Those in favor of retaining the repeal paragraph?
1, 2, 3.
So that was 7-4?
Yes.
Okay. Did we lose 2 people? Or is my math that bad? Because we had an 8-5 at one point.
Yeah.
Oh,
Does that count you? Which way did you vote? To leave it?
so is that 8?
Should be 5. I don't think I counted it.
Okay, leaving it is not 4, it'd be 5. Okay. All right. And then, since that would cause us to open this up with OLS, I would propose that on line 27 of page 1, that we change a single to an, so that it reads means an incident. And similarly, on line 30, change the a single to an.
Let me get this straight.
Yeah, so this is basically just saying an incident.
Mr. Chairman, could you ask the folks sitting at the table what their take is on changing those words, taking out single?
Yes, ma'am. I think we got their input earlier, but it's been a long time. So do you have an opinion?
So, the determining what's an incident is a big part of the discussion in the resolution of a claim. And, this bill is not going to define, that incident. It's going to be determined in the guidelines. The use of the word incident here is intended to tie to C, which is one or more incidents, right? So I think it's clear the bill does capture both incidents, you know, and allowed to be discussed both individually and collectively. And that's a long way of saying this change would be okay. Thank you.
Okay, so if you raise your hand on this straw vote, you're voting in favor of striking a single and just replacing it with the word an, A-N. So all those in favor of that change, please raise your hand. 13. Anyone opposed? I'm not seeing any opposed. Mr. Hoffman and Mr. Ripple, what I think I want to do is I want to take a committee vote, Division 1, Division 3 that are here, on the Umberger Amendment with all of the changes that we've gone through and have accepted into the next, well, I guess they're already in here, right? Okay. So we have to do one more amendment, though, to strike repeal and strike the word single. I'd like to have a vote on accepting that you guys are going to do it right so that we can get out of your way and you can get this ready for the Finance Committee. Is that within protocol? Okay.
Mr. Chairman, I'd make that motion.
All right, motion by Emery. Second. Second by Urick.
We're going to take a roll call on this, right?
Yes.
Okay, so this is, I think this is an OTPA vote with the Umberger Amendment with the two changes that we specified. Let's start with Representative Umberger. She has a question.
No, I don't have a question. We had 3 changes. We had strike paragraph 5, change line 27 to strike single,
Right.
and on line 30.
Yeah, you're
to
being
strike single.
precise. I was
Well-
considering, no, you're absolutely right. I was lumping those since they're so similar into one, but you are precise. So, do we need to change the motion? No? All right. So let's go ahead with the roll call.
Representative Emery.
Yes.
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 Representative Earp.
Yes.
Representative Weiler, yes. Representative Bean. Yes. Representative Wallner.
Yes.
Representative Long.
Yes.
Representative. Chairman Edwards.
Yes. All right. The committee, the joint committee has approved the OTPA on a 13-to-1 vote.
12 to 1.
12 to 1? Okay. That makes sense. All right.
Count money better.
So with that, I think we've completed our work here. No, we haven't. What's our more work? We have to come up with who's going to do the blurbs or what?
Thank you. I will do the blurb for the positive side. And I just wondered if there is going to be a minority.
I could possibly vote yes in full committee. I've got some things I need to think about that
Okay.
I'm concerned with this. But if I do vote no, I will write a report for it. I'm not opposed to the bill at large. There are just a few sections that I'm concerned with. So it'll be kind of a positive negative blurb.
Okay, thank you.
So Representative Rogers, trying to be precise, I think your vote is recorded as
Yes.
a no, and you can't change that unless we reopen the vote for some
No,
reason.
I'm not going to change it here. I said in full committee.
Oh, in full committee.
Right.
Okay, all right, very good. And then you'll write the blurb if you could keep your position. I got it, thank you. Okay, now I think we're done. We're going to refer this to the full Finance Committee.
On Tuesday.
Okay. So with that, thank you. It feels like a pretty good bill to me, but we don't know until we've done it for a couple of years. So, so thank you very much. With that, we'll adjourn HB 1677.
Put this in our filing cabinet with all the rest of this.